Imagine you live within a culture that genuinely believes in witches and spells, and further, you've just had a witch claim to cast a spell on you that she says will kill you by morning. Your culture also believes that a spell can be neutralized by killing the witch who cast the spell, so you do that. You kill the witch and survive the sunrise. Then you're arrested and charged with the murder of the witch. Can you justify that killing as lawful self-defense? Believe it or not, such killings and legal defenses are apparently brought up with some frequency in sub-Saharan Africa. And it turns out they treat such cases pretty much how we might do so in America. Let's discuss. And for those of you who stay to the end, I'll share with you how you can join us for our 100% free Law of Self-Defense Hard to Convict class coming up in just a few weeks. So this topic was brought to my attention by a member of the Law of Self-Defense community who sent me a link to a scholarly paper entitled Self-Defense Against Metaphysical Witch Attacks, a Legal Conundrum in Anglophone Africa. Notably, this is a recent paper. It was published only this past March. I'll include a link to the PDF version of the paper in the description of today's show so you can read it for yourself. The abstract of the paper, or the initial summary, reads, "Superstition-driven homicide is a frequent occurrence in many African societies. People charged with homicidal acts supposedly perpetrated under the influence of belief in witchcraft and juju sometimes raise the plea of self-defense or self-defense in conjunction with mistaken belief. Hence, since the latter part of British colonial rule in Africa, particularly the 1930s, the courts in Anglophone Africa have on several occasions been invited to address the question of whether killing suspected witches to repel supposed metaphysical attacks avails the accused person to pleas of self-defense or self-defense based on mistaken belief, and if so, under what conditions. Drawing on case law, statutes, and a range of pertinent academic literature, the present study explores the historical development of the self-defense based on the mistaken belief plea in witchcraft-related homicide cases in English-speaking Africa. It examines the African court's attitude toward the self-defense against metaphysical witch attacks defense, highlighting the divergent perspectives of various national and regional courts. Now, I'm not going to read through this whole paper. Again, I will link to it in the description of today's show. But the paper explores various approaches by different African jurisdictions on how they come at this culturally specific conundrum. And what I found interesting was how closely these varied approaches paralleled what one might expect in an American court of law. Importantly, the paper focuses on what it refers to as Anglophone Africa, meaning African jurisdictions whose laws were based largely on Old English common law as a result of colonization. And that explains the similarities to American law approaches because, of course, our own law of self-defense is founded upon the deep history of English common law as well. In America, the major legal defenses that might be raised to the killing of a witch committed for the purpose of saving oneself from a life-threatening spell would be three. Now, of course, there is no legal defense at all until there's a criminal charge. But for our purposes, let's presume that it is uncontested that the suspect killed the witch. He's not saying, I didn't kill the witch. He's saying, I killed the witch, but with the justification of self-defense. In that case, we'd see a charge of murder for the killing, following which the now defendant would begin presenting legal defenses to that criminal charge of murder. So the legal defenses would be perfect self-defense, imperfect self-defense, and arguably an insanity defense. Now, perfect self-defense is what we normally think of as self-defense, and it is perfect in the sense that a killing committed in perfect self-defense is simply not a crime at all and results in an acquittal. There is zero criminal culpability for taking a life in perfect self-defense. For perfect self-defense to be viable, there has to be evidence to support the 5 elements of self-defense, such that none of the required elements can be disproven by the prosecution beyond a reasonable doubt. These elements are, of course, innocence, that the defender was not the initial aggressor in the confrontation with the witch; imminence, the lethal effect of the spell was either actually taking place at the moment of the killing, or was immediately about to take place, or, arguably, if there's a time delay in the effect of the spell, that the lethal effect of the spell would be otherwise unavoidable, and for all of these scenarios that the lethal effects could be neutralized by the killing of the witch. Proportionality, the use of lethal defensive force would be proportional only if the effect of the spell would be expected to include death or serious bodily injury. And the varieties of serious bodily injury that come in the context of magic, I suppose, are pretty broad. Avoidance, this is the element that usually involves physical flight from a physical threat. I'm not sure how one flees from a spell. Perhaps in the context of a witch, this might involve the use of a talisman or counterspell to avoid the lethal spell of the witch. And finally, reasonableness, the fifth and final element of self-defense, which really has two parts, subjective and objective. That is, the defender had to have had a genuine subjective good faith belief in the lethal nature of the spell, and this is apparently not at all uncommon in much of sub-Saharan Africa, and also that the subjective belief was, in addition, objectively reasonable. That is, a hypothetical, reasonable, and prudent person would have shared that subjective belief under the circumstances. If the state can disprove any one of those 5 required elements of self-defense beyond a reasonable doubt, and that includes disproving either the subjective or objective facets of reasonableness, both are required, then the legal defense of perfect self-defense collapses entirely. Now, obviously, a rather substantive defect in raising the legal defense of perfect self-defense to justify the killing of a witch in defense against a lethal spell is that one would not expect a hypothetical, reasonable, and prudent person to actually believe in the possibility of death by magic. While this seems obvious enough on its face, it does raise some interesting cultural questions. Is the reasonable and prudent sub-Saharan to be evaluated the same as the reasonable and prudent Englishman, upon whose culture the English common law being applied in sub-Saharan courts is based? Remarkably, it seems that the long-standing rule in sub-Saharan courts is that, indeed, the legal standard to be applied is that of the reasonable and prudent Englishman, not that of the reasonable and prudent sub-Saharan. So, given that a hypothetical, reasonable, and prudent Englishman would not likely perceive a spell-based lethal threat as anything real, that spell-based lethal threat cannot be used to support a claim of perfect self-defense. Now, ironically enough, it seems that there are cases that have taken place in England in which sub-Saharan defendants are charged with a violation of English law in England and have been permitted to be judged by what would be expected of a reasonable and prudent sub-Saharan. This leads to the odd circumstance in which sub-Saharans in sub-Saharan courts are judged as Englishmen would be judged, but sub-Saharans in English courts are judged as sub-Saharans. In any case, if the standard of the hypothetical, reasonable, and prudent person is that of an Englishman, a claimed fear of a lethal spell would not be likely to be perceived as objectively reasonable. Therefore, any claim of perfect self-defense would lack objective reasonableness, lack the required element of reasonableness itself, and collapse entirely. There is, however, a variation to perfect self-defense, referred to as imperfect self-defense. Where perfect self-defense makes the underlying killing simply not a crime and results in an acquittal and zero criminal culpability, imperfect self-defense is, well, imperfect. Imperfect self-defense occurs when the defendant has an otherwise valid claim of self-defense with the single defect that they lack objective reasonableness. So they have innocence in that they did not provoke the fight. They have imminence in that the threat is occurring or about to occur or otherwise unavoidable. They have proportionality in that the threatened spell is lethal in nature or could cause serious bodily injury. I suppose if you're being turned into a newt or something. They have avoidance in that the consequences of the lethal spell could not be avoided other than by killing the witch. And they have a genuine subjective good faith belief in all of this, but their belief is objectively unreasonable, meaning that a hypothetical, reasonable, and prudent person in their circumstances would not have shared that belief. Without objective reasonableness, you cannot have perfect self-defense, but you can end up with imperfect self-defense. Now, you may be wondering how someone could possess even a genuine good faith subjective belief in the existence of lethal spells. But apparently this belief is widespread in sub-Saharan Africa. And before you mock these cultures too severely, I would just remind all of you that we have plenty of supposedly sophisticated, well-educated modern Westerners who believe in such nonsense as catastrophic anthropogenic global warming and the benefits of chemical and surgical gender transition in children. Now, the consequence of having a subjective but objectively unreasonable belief in the lethality of spells is that the killing of the witch cannot be deemed legally justified, not a crime, zero culpability, as it would under perfect self-defense. But what imperfect self-defense can do is mitigate what would have been a murder conviction to a manslaughter conviction, and the sentences. So instead of life in prison without possibility of early release, or perhaps even capital punishment and execution, the defendant instead would be subject to a manslaughter conviction and sentence, perhaps 10 to 20 years, with early release possible after a third or half of that sentence. It still sucks, but it's a lot better than life or execution. And in fact, that appears to be how many of these witch-killing cases are treated in sub-Saharan Africa. Through one means of mitigation or another, perhaps not quite paralleling the American approach, but achieving the same mitigation outcome, the defendant in a witch-killing case ends up with something more akin to a manslaughter conviction and sentence than a murder conviction and sentence. A third possible legal defense in the United States, one I didn't see argued in the scholarly paper under discussion here, is the insanity defense. An insanity defense occurs when the defendant is found to have been incapable of differentiating right from wrong in the act of killing. Typically, the standard here is pretty hard. For example, a defendant who believed the human being they killed was not a human at all, but was instead a space alien, they might qualify because then they would have lacked the intent to take a human life at all. Further, whereas the burden of proof on self-defense is on the state to disprove a required element of self-defense beyond any reasonable doubt, rather than being on the defendant to prove self-defense, it's more common for the insanity defense to be treated as a more traditional affirmative defense in which the defense has the burden of proof. And that's what I have for all of you on killing witches in purported self-defense. Okay, folks, before I wrap up, I want to share with you how to join us for our 100% free Law of Self-Defense Hard to Convict class coming up in just a few weeks. As the title suggests, this free class teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. The class is live streamed by me, and there's plenty of opportunity for Q&A. Again, the Law of Self-Defense Hard to Convict class is 100% free, but we do limit seats to allow for adequate Q&A opportunity with the attendees. So I urge you to grab your seat right now before they're all gone by signing up at lawofselfdefense.com/hard-to-convict. I'll close out by reminding you all again that if you carry a gun for self-defense, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.